Usually they think that the liability issue is too difficult compared to the damages, which are not routinely as high as, say, an automobile collision. The most common places are the big box stores, department stores, the larger grocery stores. However, it's not an overwhelming majority of the places. They pretty much can happen anywhere. Well, there's basically two. One is the inherent quality of the surface itself. Second is substances that are improperly located where the person falls. The first is that they're going to be treated properly, fairly. And the second is that a big one is that they'll make a report if there's any kind of an injury to the store, probably will be in writing, and they don't get a copy. The ideal would be to document everything that you can about the location, witnesses, and substance. Retain all of the clothing, footwear, and the do nots is the same as I just said. Do not presume that you're going to be treated properly. Do not presume that the very kind manager that comes over to help you is going to remain that way when the time comes to file a claim. As a general statement under Washington's Landlord-Tenant Act, there has to be specific circumstances. One, a hidden hazard, or two, a failure to do something, for example, to prevent injuries due to ice. It depends on the cause. If it's something that the tenant did, the tenant's negligence, the tenant would be responsible. If the landlord has violated a provision of the Landlord-Tenant Act, and as far as keeping the premises safe, the landlord. The same basic answer. These cases are fact-driven. There has to be a reason for the fall, and that reason has to be include negligence of some sort. I wouldn't be in business if insurance companies treated claimants fairly. The first thing, in my opinion, that they should do is contact somebody who can confirm whether or not there's a possibility that somebody should be held responsible. That is contacting me or another lawyer. For two reasons. One, you get an initial opinion, but number two, if it's soon after the fall, there's evidence that may be preserved, because landlords or at-fault parties are not above changing the circumstances. In fact, it happens frequently, to try and hide facts that will be helpful. It's the same as any other case. The elements that are easiest to include: wage loss, medical bills, and of course the most difficult question is pain and suffering. Now, with any case, and that includes premises, you put into the mix the question or the weight of evidence for liability. Liability 100%, the maximum. Liability less than that, that reduces the amount. As far as a specific amount, we don't know until the client is healed and ready to go. We have all the information. Then, like with any case, everyone is unique. Well, I guess a red flag would be, and we'll just limit this to advertising, because I believe the first lawyer you should go to is one recommended by a friend who you respect. Having said that, advertising today is the way most folks come in, and but I think that with premises cases, the first thing that you should do is see whether or not the lawyer does the premises case. Then how long the lawyer has been in business, and then what folks that he has worked for say about him. It's a safe bet if the lawyer does premises cases, you call him, you'll get an answer and a discussion whether or not you should go forward.